King, Ms. Nelson, Ms. Higgs, and Ms. Spengler, and the prosecution is represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Ms. Tish McGuire, and Mr. Edson. We are outside the presence of the jury. I think it makes sense to have the parties not contact any of these dismissed jurors until the proceedings are over. If the parties are intending to contact them, I can hear argument on that. Do the parties know at this time whether they're intending to do that before the proceedings are over?
It hadn't crossed our mind to do it, and we don't have any intention to do so, Your Honor.
Mr. King?
Judge, if we decide that we need to do that for some reason, we can bring it to the court's attention.
Please, thank you. All right. Let's bring the jury in, please. Can you give this back to Adam, please? Should Dr. Metzler take this back? Yes, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Good afternoon, folks. I want to thank you for your patience today. I hope you enjoyed your lunch. I know we had lunch brought in. We figured we would do that given how long you had to wait for us, but I very much appreciate how patient you've been. You may have noticed, or you may be noticing now, that there are 3 of you missing. We've lost 3 jurors. Please don't speculate about that. Don't think about why that happened or what happened. You should not speculate about any of that. I have prohibited those 3 jurors from having any contact with you related to this case, and I am prohibiting you from having any contact whatsoever with them. I say whatsoever because, frankly, given that this is where you met, if one of them contacts you, it seems to me almost impossible that something about this case is not going to come up. So don't you are, as one of the advisements that I have been giving you with respect to your conduct when you're not here in the courtroom, there's one that I'm adding, and that is you cannot have any contact of any kind with any of these 3 jurors who have been released, whether it's by phone, whether it's through email, whether it's in person, social media, through any means. No contact about anything, whether related to the case or not. Does everybody understand that? Yes. And everybody's nodding their head yes and saying yes. Okay, great, thank you. At the end of the day yesterday, Dr. Reed was on the witness stand. Dr. Metzner, this is what happens when you say it so many times. Dr. Metzner was on the witness stand, And now Dr. Metzner has resumed the witness stand. And I remind you, Dr. Metzner, that you're still under oath. And before I allow Mr. Brockler to proceed with the rest of his redirect examination, I want to remind you, members of the jury, that the court has admitted the testimony of Dr. Metzner only for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. Please remember that whenever I refer in this trial to the issues raised by the defendant's plea of not guilty by reason of insanity, and I have referred to that before, I mean two questions, and that is issues related to two questions. Number one, whether the defendant was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. And number two, whether the defendant suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an element of a crime charged. I mentioned yesterday that I have told you in the past about the elements that make up each of the crimes charged in this case. One of the elements of each of the crimes charged in this case is sanity. The prosecution has to prove beyond a reasonable doubt each and every element of each crime charged, and one of those elements is that the defendant was not insane at the time of the commission of the act. And so when I talk about evidence being admitted only for the limited purpose of the issues raised by the defendant's plea of not guilty by insanity, not guilty by reason of insanity, I mean only related to that one element. Okay, so you cannot consider it with respect to any other element of any crime charge. Does that make sense to everyone? Yes. Everybody understands that, and everybody's nodding their head yes and saying yes. Okay, with that, Mr. Brockler, you may proceed with the rest of your redirect examination of Dr. Metzner. Thank you.
Thank you, Your Honor. Dr. Metzner, yesterday there was some conversation during cross-examination about malingering and the tests that were validity tests and tests for malingering. Do you remember that?
I do.
I want to make sure that we're clear on what those tests and your opinions about malingering are and what they are not. Are those validity tests and those tests for malingering, are those guarantees of accuracy or trustworthiness for all the statements that the defendant makes?
No.
What is it that they're talking about when you talk about malingering?
What those tests talk about and my opinions when I'm talking about malingering, I think the tests are very consistent with my opinion that Mr. Holmes wasn't faking a mental illness. And that's what those tests say. What those tests don't say is that every statement that Mr. Holmes has told me at least, is either accurate or reliable. But that's different than malingering.
Give us some examples of some of the reliability issues that you came across that are not dispelled by these malingering tests.
Well, for example, there's, as I've testified before, there's certain information that I received from Mr. Holmes that was different around the same event that, say, Dr. Gurr received from Mr. Holmes. And so both of those statements, one of those statements is probably not accurate. And so malingering test doesn't say anything about that. And the fact that they're not accurate just means that's an example of a statement that may not be reliable, despite him not malingering. There's no question he has an illness.
Let's talk about the unreliable statements then. What statement did he make to you that differs from what he told Dr. Gurr regarding what he thought he'd accomplish inside the theater?
So he
all been asked and answered and gone over.
Overruled?
Go ahead, sir.
So he told me the goal of going to the theater was to shoot as many people as he could. And he told Dr. Gurr that...
I'm going to object as to what he told Dr. Gurr.
Overruled?
Go ahead, sir.
What was in Dr. Gurr's report was that he told Dr. Gurr that he didn't think that he would kill people, that it would harm people. That's a pretty big difference. And so that's an example.
There was some question by Mr. King on cross-examination about trying to suggest an alternate explanation for a call for action and his reference to needing to take action. Do you recall that?
Yes.
I want to ask you, and again, under the caption here, reliability, did you specifically ask the defendant about a quoted phrase from Dr. Gurr's report?
I did.
And it appears how many times do you think in that report? Multiple?
Yes.
And when you asked the defendant specifically about that phrase in quotes in Dr. Gurr's report, tell us what he told you.
Okay, I just want to be accurate.
Yes, sir.
I'll give you the page number in a minute. I'm looking at my report.
And I'm objecting, Judge. This has been asked and answered very clearly.
Overruled. And it's overruled under Rule 611A.
Well, specifically I'm referring to page 7. Specifically with regards to the quotes call for action, he just made it clear to me that he had not used that phrase, call for action.
Now, did you follow up with Dr. Gurr about that to see if maybe there had been a mistake or she'd misheard it?
I did.
What'd she say?
And she said that he had used the term call for action.
Did you confront the defendant about that?
Objection, asked and answered.
Overruled.
Yes, and he didn't have an explanation for the discrepancy.
Now, Mr. King had asked you before on cross-examination about whether delusions have the ability to change over time. Do you remember that?
Yes.
Is this what we're talking about right here, in your opinion, the result of some sort of change delusion?
No, I don't think that is an example of that.
Another one, another area that you touched upon. He told you why he didn't study for those prelims. Do you remember that?
Yes.
What was it he told you?
What he told me was that he had always studied in the past due to fear of not doing well and not pleasing others, and he decided he was going to be himself and not do it because of fear.
Now, did you find a statement that he made to Dr. Reed to be in contrast to that, calling into question the reliability of that statement?
Objection, leading.
Sustain as to leading. You can rephrase the question, and that ruling is pursuant to Rule 611C.
It's also beyond the scope of my cross-examination. I didn't ask this doctor about any statements made to Dr. Reed.
The objection as to beyond the scope is overruled under Rule 611B.
Did he give an answer about why he didn't study to Dr. Reed?
Yes.
Was that answer consistent with what he gave you?
It was different than the answer that he gave me.
You remember what he gave Dr. Reed?
I believe that the answer that he gave Dr. Reed was...
Judge, I'm going to object to any speculation about what the statement was.
All right. Why don't you establish foundation with respect to the statement made to Dr. Reed and this witness's knowledge of that statement,
Yes,
if
sir.
any?
Yes, sir. Did you review the videotape, the 22 hours of videotape that Dr. Reed took of his assessment of the defendant?
I reviewed that and the transcript of the videotape.
And based on that, do you know what it was that the defendant gave as a reason why he didn't study with Dr. Reed?
I can tell you what my memory is of what that was.
Yes, sir.
My memory of what that was is it had to do with it would be suspicious if he just dropped out of school, and that by failing, that wouldn't raise suspicions.
There was some conversation, do you recall, in cross-examination about the defendant's interactions with Drs. Fenton and Feinstein. Do you recall that?
Yes.
One of the things that Mr. King asked you about was about possible manic impacts caused by some of the drugs that were prescribed by Dr. Fenton. Do you recall that conversation?
Yes.
To your knowledge, based on what you reviewed from Drs. Fenton and Feinstein, as well as your conversations with them, did the defendant ever report to them feeling manic?
He did not.
Did they ever observe him displaying manic symptoms?
They did not.
How about depression? Did he ever express to them that he was depressed?
He told me on at least one occasion that he did. They said that he had not.
And that's borne out too by their notes.
Correct.
Did he ever display to them any symptoms of seeming depressed?
They didn't observe that.
How about suicide? Did they ask him whether or not he was feeling suicidal or had suicidal thoughts? I'm sorry. We're doing real-time looking at the transcript. I just want to make sure the last answer to the question about did they observe any signs of depression with the defendant, you said what?
I said I do not think that they did.
Okay. In terms of feeling suicidal, did they ask the defendant, in fact, when I say they, I mean Ms. Roth, Dr. Fenton, Dr. Feinstein, did they ask him whether he was feeling suicidal?
Yes.
And what did he tell them?
And he denied suicidal thinking.
Every time?
Correct.
In fact, did he answer a question about whether or not he'd ever attempted suicide with them?
I believe so, and there wasn't a history of past suicide attempts that was elicited.
Thank you. One of the other things that was talked about in cross-examination was this idea of someone believing that something was illegally wrong, but could they then believe that it was still socially acceptable? Do you recall that exchange?
Yes.
Can you, and I should have done this in direct, but in light of cross, can you give us an example of something that someone could do in terms of a crime that is illegal, and they'd know it was illegal, but they would believe that it was socially acceptable or within the societal standards of morality?
Objection is to relevance.
Overruled?
Go ahead, sir.
A person could have a paranoid delusion in which the delusion was that Joe Smith is going to kill my family. And Joe Smith could come to the house, and the person could shoot Joe Smith because he thought what he was doing was morally right within societal standards because he was defending his family. But it was all based on a delusional concept, even though he knew that killing someone was illegal. That would be an example.
Thank you. Anything like that applicable here to these facts?
Objection calls for speculation.
Overruled?
Well, that was the assessment that I had to make because, as I've said before, Mr. Holmes had a delusion. He acted on the delusion, which was related to everything that he did. But in my opinion, for the reasons I've already given, I thought that he had the capacity to distinguish the difference between right from wrong at the time of the commission of the alleged acts.
Let's go even farther. Did the defendant at any time during your 25.5 hours with him ever express to you that he believed that what he did was either socially acceptable or that society would accept and agree with what he did?
No.
Are there any actions that you have seen in the now 90,000 plus pages of discovery, the videos, the audio, the pictures, everything, that suggest that the defendant believed that what he had done in that theater by murdering those people and trying to kill the others would have been socially acceptable or that society would understand and approve of it?
No.
Again, in terms of talking about the capacity to know right from wrong based on societal standards of morality, is being delusional and thus having a psychosis, does that mean automatically you lack the capacity to know right from wrong?
Objection asked and answered.
Overruled?
It does not.
The delusion here you have talked about really in two parts. Is that true?
Yes.
Is one of those parts that the defendant believed he would increase his self-worth by murdering people?
Correct.
And the other part is that he would feel better?
Objection, asked and answered.
Sustained.
Doctor, is the part of the delusion about increasing his self-worth also in part about making himself feel better because of the increased self-worth?
Objection, asked and answered.
Sustained.
When the defendant carried out his 2.5+ month plans on the 19th and 20th of July, is it your opinion that he was doing that he intended to kill people to make himself feel better?
Objection, Your Honor, calls for the ultimate conclusion. Invading the province of the jury.
All right, give me just a moment.
It's invading the province of the jury.
The objection is overruled. Doctor, if you can answer it without speculating based on an opinion that you have or based on your expertise, then you're permitted to answer it.
Can I have the question repeated?
Yes, Mr. Brocker, do you want to repeat the question?
Can I have a moment, Your Honor?
Yes.
I think, because I put a lot of words in it, I'm sorry. I think what I was asking you was, is it your opinion that the defendant's decision to carry out to execute this 2.5 month plan on the 19th and 20th of July to include killing those people in that theater was to make himself feel better?
Objection, asked and answered.
Overruled.
Yes, that was part of his delusional belief, and it's my opinion that that's why he did that.
Can we understand, in your opinion, that desire to increase his self-worth and that desire to feel better as his motivation for why he did what he did?
Yes.
May I have a moment, Your Honor?
Yes. All right, Mr. King, do you have any recross for Dr. Metzner?
Yes, Your Honor. Very brief. Doctor, you were asked some questions about some alleged inconsistencies in statements that were made by Mr. Holmes. Suffice it to say, the fact that you find inconsistencies in what one person says over time when they're relating events that happened years before they were medicated, and when they were in a psychotic state, that doesn't mean that they're malingering, does it?
No, it does not mean that they're malingering.
And those inconsistencies did not have a significant impact on your opinions, did they?
That's correct.
Very few evaluations, very few, with the kind of history and investigation that took place in this case, will you find no inconsistencies, correct?
Correct.
As a matter of fact, if someone were to be completely consistent when they recalled events to you over and over again, that would cause you concern that they might be malingering, because that would suggest that they had planned it out or had been coached, correct?
Would be concerning.
So the fact that there are inconsistencies is not concerning in terms of your opinions. Fair to say?
It doesn't change my opinions, and it depends on the nature of the inconsistencies. I would not say that none of those inconsistencies are not concerning, but I would agree with you that none of those inconsistencies changes my opinion.
Now, Mr. Brockler just asked you about making himself feel better. Now, to be clear, is this making himself feel better in kind of a physical way?
No.
Is it making himself feel better? Is that a psychotic concept for him to have, that killing other people would alleviate his depression and make him feel better?
It was a psychotic concept.
A psychotic delusion, and that's what the shooting was based on. Is that correct?
That's correct.
I don't have any other questions.
All right, thank you. Dr. Metzner, the jury may have questions for you. Could you give us a moment, please?
Yes.
Thank you. Thank you. Would counsel please approach? Members of the jury, I have a little bit of an unusual request. So just go along with me if you would. Indulge me, please. I know that you submitted, there are 3 forms with questions, and I don't know who submitted the questions, and I don't need to know who submitted the questions. As you know, these are anonymous. But the folks who submitted these questions, and it appears to be 3 different people based on the handwriting being different on the forms. If you would please resubmit the questions, I would appreciate that. So those of you who submitted questions for Dr. Metzner, if you would write them again, and then my staff will come and collect them from you, okay? So I'll give you a moment. I'm not going to look your way because I don't want to know who's submitting questions. All right, we'll take a moment to have you do that. Thank you. Thank you for indulging me. And Dr. Metzner, thank you for your patience. No problem. Thank you. Would counsel please approach? This is what they call deja vu all over again. Dr. Metzner, the jury has submitted 3 questions that are related, and I have found that these questions are appropriate based under the rules of evidence and other applicable rules of law. The first question, I'm going to read all 3 of them together, and if you need me to repeat any part of it, you let me know. The question is as follows. When was Zoloft prescribed? How long to start showing effects? How long until full effect?
Let me give you the exact date. I want to, because it's in Dr. Fenton's notes, so I'm going to refer, I think it was the second session, but let me look it up and I'll give you the page number from my report. So, Dr. Fenton's first saw Mr. Holmes on March 21st, and that's when Zoloft was initially prescribed. It was initially prescribed 50 milligrams a day with the plan to increase it to 100 to 200 milligrams. And then the question was, how long does it take effect? Let me answer it 2 ways. To remind the jury that Zoloft, despite it being called an antidepressant medication, it's used for other things, and it was specifically prescribed for his obsessive-compulsive symptoms. For depression, once you get a therapeutic dose, and the 50 milligrams, most people would say it's not a therapeutic dose, what you tell a patient is this could take 4 to 6 weeks before it takes effect. Some people it works much faster, but you got to be on a therapeutic dose for at least 4 to 6 weeks before it takes effect. Now, that's for depression. I think for obsessive-compulsive traits, you would say the same thing, that some people will get an effect fairly soon, most people don't, and you'll tell them you got to be on it for at least 4 to 6 weeks. I don't think that, let me just look at a couple other records about the Zoloft. It was increased on April 17 to 150 milligrams. So that's the best. I think, was there a third part to that question?
The second part was how long to start showing effects, which I think you've answered. The last part was how long till full effect, and you may have answered that as well.
Yes, you got to be on it for 4 to. If you're not getting an effect within 6 weeks, then you would say we have to try another medication.
Any follow-up questions based on those questions and answers, Mr. Broccoli?
Yes, Your Honor, thank you.
Okay.
Hey, Doctor, given when it was prescribed that you've testified to, during the time that the defendant was seeing Drs. Fenton and Feinstein, would we expect to see any effects from that sertraline, that Zoloft that had been prescribed during the period of time that he had been seen by them?
It's possible, and again, remember the history that he gave me is that once he got on sertraline, that if you read his notebook, that's when he describes manic-like symptoms. That's also when he describes losing the fear. And it's conceivable that that was related to the medication.
Now, do you prescribe sertraline?
Yes.
And you have for a long time?
Yes.
In this particular case, you've already testified on redirect that there was no observed or reported manic symptoms to Drs. Fenton and Feinstein. Did the defendant ever report any ill or otherwise side effects from the sertraline to Drs. Fenton and Feinstein that you're aware of?
Objection asked and answered.
Overruled?
I don't think that he reported symptoms. related to that.
And you had also testified earlier, was it this drug or some other drug that you said he had discontinued on his own?
I think that I had mentioned that he had stopped the Zoloft, the sertraline. I'm not sure of that too. I'm not sure whether he in fact did that or not.
Do you have an opinion as to whether or not, for the point of this question, do you have an opinion as to whether or not the sertraline is what caused this murderous conduct by the defendant?
Judge, objection. This is way beyond the scope of the juror's question. The juror's question just related to when and how the effects take effect.
Mr. Brockler?
Well, Your Honor, I think the question is when would this reach full effect? And I mean, I can rephrase the question to be, would the full effect have caused him to...
I'll sustain the objection. You can rephrase your question and we'll see if there's an objection.
Doctor, for whatever is meant by the full effect of sertraline, do you have an opinion as to whether or not the full effect of sertraline, based on what was prescribed and when it was prescribed, would have caused the defendant to not have the capacity to know right from wrong based on societal standards of morality, or to be able to form the culpable mental states related to the crimes in this case?
Objection, Judge. Way beyond the scope of the juror's question.
Overruled.
I don't think the sertraline had an impact on whether he did or did not have the capacity to distinguish the difference between right from wrong.
Thank you.
All right, any follow-up questions from you, Mr. King?
Just one. You do think that the sertraline may have made the mental illness worse and may have contributed to the delusional beliefs that he ended up acting on?
I don't think it contributed to delusional beliefs. He had the delusional beliefs before. I think it's, for a short period of time, it's conceivable that it could have made his condition worse.
All right, may Dr. Metzner be released from his subpoena? Okay. All right, Dr. Metzner, you're subject to being called again, okay? But you're done for now. Thank you.
Thank you.
All right, thank you for your patience today. Thank you.
Your
All
Honor,
right, Mr. Orman, call your next witness,
before we
please.
do that, can I approach with counsel, Your Honor, just to
Yes.
ask the question of the court?
Yep. Ms. Pearson, call your next
Your Honor, the
witness.
people call Dale Higashi.
Good afternoon. Good afternoon. Solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
All right, please be seated.
Thank you, Your Honor.
Could you please tell us your full name for the record and spell your first, middle, and last names?
Certainly. Dale Mikio Higashi, D-A-L-E. Middle name is M-I-K-I-O. Last name is H-I-G-A-S-H-I.
All right, Ms. Pearson, you may proceed.
Agent Higashi, would you tell us where you work, please?
Okay, I am currently employed by the Colorado Bureau of Investigation.
What does the Colorado Bureau of Investigation do?
We have a forensic laboratory that supports most of the local agencies throughout the state, other than the Denver Police Department and Colorado Springs. We service all of those agencies with our forensic services, and we also have an investigative staff that helps regular investigations throughout the state.
Are there different disciplines at the Colorado Bureau of Investigation, and is that called CBI?
Yes, the CBI laboratory has probably 6 or 7 different disciplines. I'd have to count.
Which one do you work in?
I work in the firearms and tool mark section.
How long have you been employed at CBI?
I've been there for coming up on 11 years.
What's your actual title at CBI?
It's a laboratory agent.
What do your duties consist of?
My duties in the firearms section are to analyze firearms and firearms-related evidence. We help detectives determine type and caliber of unknown shootings, let's say, if we get fired bullets or fired casings submitted to the laboratory. If they happen to recover a firearm involved, I'll go through that firearm, make sure that it functions properly. I'll attempt to test fire that firearm to generate exemplars of what that particular gun does to fired bullets and fired casings. I'll also determine if the gun is capable of inflicting serious injury or death, and ultimately make those comparisons between the fired ammunition evidence to the test-fired bullets and cartridge cases from that suspect firearm, and make a determination if that is indeed the gun used in the commission of that crime.
Do you have other duties at CBI as well?
Yes, I do.
What are those?
I also serve as our department armorer, so I'm the one that helps maintain the agents' firearms, make sure that they're working properly, and I'm also one of the firearms instructors.
What kind of weapons do you maintain as an armorer at CBI?
At CBI, our normal issued duty firearm is a Glock 23, a 40 Smith & Wesson caliber semi-automatic pistol. We also have some Colt semi-automatic AR-15s and Remington 870 shotguns.
Now, did you also say that you're a range officer?
Yes, ma'am.
And what do you do as a range officer?
We help instruct our field agents in the proper use of their firearms, pistols, rifles, and shotguns.
Where did you work prior to joining CBI?
Prior to CBI, I was a senior criminalist with the Los Angeles County Sheriff's Department Crime Lab.
What did you do there in Los Angeles?
For the first 4 years, I was a narcotics chemist where I analyzed drugs. And then from 1990 to 2004, I worked in their firearms section.
What's your educational background?
I have a Bachelor of Science degree in microbiology from California State University at Long Beach.
Now, you indicated that you first became a firearms, or you worked as a firearms examiner beginning in 1990.
Yes, ma'am.
What kind of training did you have to become a firearms and tool mark examiner?
I underwent a 2-year training program. I worked under the direct supervision of 4 other examiners in Los Angeles who had in excess of 40 years experience with firearms identification. So I underwent the 2-year training program that's laid out by an association that most firearms examiners belong to. It's called the Association of Firearms and Tool Mark Examiners.
Since that time, have you continued to have training in firearms and tool mark examination?
Yes.
How do you undergo additional training?
Additional training can consist of going to the seminars that they put on and other firearms-related information that I can gather. Sometimes I'll go to the weapons manufacturers. They put on something in Las Vegas called the SHOT Show, where they bring out new guns, new ammunition components that are available to the public. So that's, again, something that a firearms examiner wants to be on top of. So it varies, but there's always continuing education in my field.
Do you belong to any professional associations that are related to firearms and tool mark examination?
Yes, I am a regular member of the Association of Firearms and Tool Mark Examiners.
Do you stay up to date with new developments and changes in the field of firearms and tool mark examination?
Yes, I do, and I'm on their website pretty much daily.
Have you testified as an expert in the field of firearms and tool mark examination?
Yes, I have.
Could you tell us how many times and in what counties or what states?
Okay. In the state of Colorado, in excess of 130 times, and I've been all over the state, from the south, Huerfano County, out in Durango. I've been out west and most of the metro area. And then in the state of California, I would estimate probably close to 500 prior occasions in mostly Los Angeles County Superior Courts.
Your Honor, I would move for the admittance of Dale Higashi as an expert in the forensic examination of ballistics, firearms, and tool marks.
Without objection.
All right. Without objection and pursuant to Rule 702 of the Colorado Rules of Evidence, the Colorado Supreme Court's decision in People v. Schreck, 22 Pacific 3rd, 68, Colorado 2001, and my previous ruling in this case, which is Order D-110A, the court qualifies Agent Dale Higashi as an expert witness in the field of, did you say firearms?
Your Honor, I asked for the forensic examination of ballistics, firearms, and tool marks.
In the field of forensic examination of ballistics, firearms, and tool marks. And so, members of the jury, what that means is that Agent Higashi has now been accepted by the court as an expert witness, and he may now render expert opinions in the field of the forensic examination of ballistics, firearms, and tool marks. Please keep in mind that you're not bound by the testimony of a witness who testifies as an expert. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it, or none of it. The weight that you give the testimony is entirely your decision. Before you proceed, would counsel please approach for just a moment? All right, Ms. Pearson, you may proceed.
First of all, Agent Higashi, what are tool marks?
Tool marks are any marks made, a tool is considered a hard object. It's any mark that would make on a softer object. So if you can imagine a screwdriver, not being used as a screwdriver, maybe as a pry tool against a metal strike plate, the harder surface of the tool, the screwdriver, can impart its own unique signature based on how it was made onto the surface of the strike plate. If that were part of my investigation, I might have the screwdriver, the marks on the strike plate, and it would be my task to look at those particular marks on the strike plate versus the screwdriver. So I would take the screwdriver, make similar type marks in another type strike plate or another medium, and compare those marks to see if I could, based on my training and education, could render an opinion of those, the interpretation of those marks.
Now, when we're talking about firearms and ammunition, how do tool marks come into play?
Okay, the firearm would just become a specialized tool. So the inside of the barrel will have rifling marks placed there by the manufacturer. Those will be the tools that are going to impart their own little signature onto the surface of the bullets. So when the bullets are fired and they go down the barrel of the firearm, it can pick up the minute imperfections from the barrel making process, have those imparted onto the surface of the bullet, and become interpretable by a firearms examiner. The same thing goes with the other part of a round of ammunition called a cartridge case. This will come in contact with a part of a firearm called the slide. In that slide, there's different tools or different areas that can mark cartridge cases. And those are the things that a firearms examiner would look at to help make a determination if that fired casing or that fired bullet was fired in a particular firearm.
Does each firearm have a unique rifling characteristic to it?
They have what we call general rifling characteristics. So a family of weapons will have a class characteristic. These are put there on purpose by the manufacturer. So let's say the Smith & Wesson rifle that I looked at in this case would have 5 lands and grooves and a right-hand twist. Every Smith & Wesson M&P 15 would have those class characteristics, but each one would get its own set of individual characteristics based on the barrel being made, being finished, being assembled and put into a firearm. Those could all impart their own individual signature on the inside of the barrel that would then translate to the surface of a bullet.
What are lands and grooves, and what's a right-hand twist?
Okay. Lands and grooves. The lands are the raised portions. If you look down the barrel of an unloaded rifle or pistol, it'll have raised portions and lowered portions. So the raised portions are the lands. Those are what will cut into the surface of the bullet and impart a spin. So the direction of twist, they have to go one way, right or left. So if you look down the surface of the barrel, and what I do is I follow the way the lands curve, and that will give you the direction of twist. If you follow it and it goes to the right, my right arm, that's a right-handed twist, and the bullet, as it comes out, will have a right-handed twist to it. If it goes the other way, a left-handed twist, it will impart a left-handed spin to the bullet and actually cut grooves into the surface of the bullet, and will have a left-handed, they'll lean to the left.
At some point, were you asked to work on this case?
Yes, I was.
What were you asked to do?
I was asked to examine all the firearms in this particular case, all the fired cartridge cases, shot shells, and pistol cartridge cases, and bullet fragments to determine if they came from any of the firearms that were submitted.
And in what order did you do your examination? What did you do first? How did you go through looking at firearms, ammunition, etc.?
Okay. First of all, I would examine the firearms, one, to see if they function properly, see if their integrity is sound enough for me to test fire them without causing damage to me. I'll then look at some of the evidence in the case to see what I need to shoot. I want to shoot similar ammunition from our collection so I can get the best known exemplars from these firearms that are given to me that will be suitable for comparison to all the evidence in this case. Then once I generate test fires and I know the firearms function properly, then the task of comparing like items to like items begin.
Before we get to your results in this case, I'd like to actually talk about firearms and ammunition in general and how guns work.
Okay.
Did you bring some firearms with you today?
Yes, I did.
And I see a couple of bags behind you. What did you bring with you?
I brought a Glock Model 22, a 40 Smith & Wesson caliber semi-automatic pistol. I brought a Colt AR-15, one of our duty firearms, and I also brought in a Remington 12-gauge 870 shotgun, also that's one of our duty firearms.
Now, is that a Glock 22, is that the same model of Glock as we have, that we've previously admitted and identified as being recovered in this case?
Yes, ma'am.
And the Remington 870 shotgun, is that like the Remington 870 shotgun that we collected in this case?
Yes, it is.
Now, the Colt AR-15, is that like the Smith & Wesson MP-15 that we recovered in this case?
Yes, it is. It's very similar. The parts would interchange. It's just that this is one that we had that I was made available to me that I could actually remove the firing pin. Actually, all the guns, the firing pins have been removed for court safety. I also have dummy ammunition that's incapable of being fired, so I could.
Judge, before we do this, may we approach?
Yes. All right, the objection is overruled. Ms. Pearson, you may proceed.
Your Honor, did you want to take the afternoon break before we begin?
Let's do that. It's 3:15. Maybe members of the jury, let's go ahead and take our afternoon break. Please keep in mind all the advisements I've been giving you. They are extremely important. They all apply. They're not just suggestions, they are requirements, and each and every one of you must follow each and every one of those advisements, including the one that I added earlier today, which is you are to have no contact whatsoever with the 3 jurors who are no longer here. As much as you may wish to have contact with them or to perhaps find out what happened or to chat with them, you must resist the temptation to do that. And again, understand that these are strict, and I expect each and every one of you to follow all of these advisements, okay? Enjoy the break. I'll see you back here in 20 minutes. Please be seated, everyone. The record should reflect that the jury has left the courtroom. Is there anything we need to talk about before we go on break? No? No? Okay, enjoy the break. I'll see you in 20. The court will be in recess.
Please rise.
Yeah, where you can, so, we'll,